All right, good evening, everybody. Tonight, my name is Jim Went. I'm the chairman of the Zoning Board of Appeals, and I will call this regular meeting of December 3rd, I'm looking at minutes, I'm sorry, January 7th, 2025. Don't panic, everybody. Uh, to order, joining me on the call are members Ben Maini, Ron Stelmack, uh, Christina McPhail, and alternates Brendan Liberati and Margaret Lee, as well as Planning and Zoning Administrator Kathleen Gallagher. It would be Mr. Liberati's turn to sit for Sarah Harris, but I see now Sarah Harris appearing, so she is
Yep, I'm here.
now present. So we have all five regular members present this evening. So I would ask Kathleen if you could read the notice of public hearing, please.
In accordance with Connecticut General State Statutes, Section 8/7D, a public hearing will be held on January 7th, 2025 at 7 p.m. or soon thereafter via fully remote Zoom meeting, considering the following application: ZBA 2024-09, file number 1430. 81 Georges Lane, application for a proposed variance to section 3.158 to permit a 4.5-foot rear setback in lieu of the required 25 feet and a 0.0-foot side setback in lieu of the 25 feet for a pre-existing shed in connection with a proposed lot line revision located at 81 Georges Lane. It was published in the CT Post twice on December 24th and January 2nd, 2025.
Okay, thank you. This is our only matter for public hearing this evening. I see Mr. Carroll is here representing the applicants. The floor is yours, sir. You may begin and explain to us what your application is all about.
Thank you, Mr. Chairman, and good evening, members of the board. My name is Wilson Carroll. I'm an attorney with Cohen & Wolfe at 1115 Broad Street, Bridgeport. I'm here tonight on behalf of Anand and Ardhana Hugar, and specifically the Ardhana and Anand Hugar Trust, which is the owner of 81 Georges Lane, Monroe. And you'll see that Mr. and Mrs. Hugar are also on the call with me tonight. And I'd just like to note for the record, I'm recovering from a little bit of a cold, so I'll do my best to mute myself if I cough, but I can't guarantee 100% on that. We're requesting variances from regulation section 3.1.5 regarding the property's side and rear yard setbacks to allow the Hugar's accessory shed to remain in its current location where it has been since at least 2008. So a little background is necessary to understand the reason we're in front of you tonight. So the Hugars purchased this property in 2010, at which point the shed was already in its current location. If you take a look at Exhibit 1 to my cover letter that I submitted, you'll see that the property's field card shows the shed as an existing outbuilding as of 2008. And the property also has a well cap in its backyard, which is close to the shed. And if you refer to Exhibit 2 to my cover letter, you'll see that there is a well completion report by the DCP, which shows that the well was installed in 1989 when the residence was originally constructed. So now if we fast forward to the beginning of last year, 2024, the Hugar's neighbors at 190 Turkey Roost Road, who are Julio and Cindy Ochoa, they had a survey done of their property, 190 Turkey Roost Road. And that survey revealed that the Hugar's shed and well cap were actually located on the Ochoa's record property, as opposed to the Hugar's record property. That discovery caused both the Hugars and the Ochoas to hire attorneys. And I've been working with the Hugars and the Ochoa's attorney ever since in an effort to resolve this title issue. Now, one potential way that an issue like this can be resolved is by filing a lawsuit. It would be a quiet title lawsuit for adverse possession. And what that would mean is that since the shed and the well cap have been in place for at least 15 years, the Hugars could claim that they are entitled to adverse possession of the area that includes the shed and the well cap. But as I think you all can appreciate, litigation between neighbors is time-consuming, it's expensive, and it has a tendency to ruin relationships between neighbors. So neither the Hugars nor the Ochoas wanted to go down that road if there was any possible alternative. So for the last year, we've been working on a settlement agreement and a proposed lot line revision. And where we've landed is that the Hugars are proposed to purchase a small portion of the Ochoa's record property, and that's the portion that includes the shed and the well cap. And then the Hugars would record a lot line revision to show the new boundary line. We've designed the lot line revision to transfer the smallest possible portion of the Ochoa property to the Hugars, which would mean that 190 Turkey Roost Road would still be a 1-acre zoning compliant parcel even after the transfer. And Ms. Gallagher, if possible, I'd like to share my screen. I don't know if do I already have the ability to do that?
Yes, I made you a co-host.
Great. Let me make that happen here. Screen 2. Okay, so can everyone see this?
We can.
Great. So this is a survey of 81 George's Lane. So this is the Hugars property, and I'll zoom in on the boundary line here. So you can see right here, the record property line horizontally, then the existing shed right across the boundary, and then this little circle is the well cap right there. Now let's turn to the lot line revision plan. It's a little bit tricky because this is basically a south to north projection, but then as we go to this survey, it's flipped. So on the bottom, this is actually the Ochoa's property, and then on top is the Hugars property. And I'll zoom in here on the same area we're talking about. So here you can see the proposed lot line revision, which would alter the property boundary to include the shed and the well cap within the Hugar property boundary. And the location of this shed is not proposed to be changed, but as you can see, it's currently placed directly on the side property boundary of both lots. And it would be located 4.5 feet from the new rear boundary of the proposed Hugar boundary. As you can also see from this lot line revision plan, I'll move over to the zoning table. So this is the zoning table that concerns 190 Turkey Roost Road. And as you can see from this table, the 1,125 square foot portion of property that's proposed to be transferred to the Hugars would still leave 190 Turkey Roost Road at exactly 1 acre. So it would still be zoning compliant as to the lot area. And I'd also like to show you some aerial photos of the property that I took today, which I think are helpful for context. So this is a screenshot from Google Maps that I took today. The one with the red dot here is the Hugars property, that's 81 George's Lane. And then right across this gap of woods is 190 Turkey Roost Road. You can see that the area between the properties is very densely wooded. And actually the 81 George's Lane is completely surrounded by this dense woods. And I'll scroll down. We can compare this now to a screenshot from Monroe GIS, which I also took today. This is the top topography with contours. So it's the same angle, 81 here and a 190 Turkey Roost on the top left. You can see that there's a steep decline from the Hugars property to the Ochoa's property. So the shed is right here. I think you can see just over the yellow line. This is at about a 464-foot contour. So the elevation is 464 feet. And then as we move down this pretty steep hill towards the lawn, the Ochoa's lawn, their lawn begins right around 424, 422. So we're talking about around a 40-foot difference in elevation between the two properties. And the reason I bring that up is because I've visited both of these properties a number of times. And to any observer, there's no indication that this shed or well cap is outside of the record property boundary. So for example, you walk up the driveway at 81 George's Lane and you enter the backyard, relatively small backyard here, and then a shed right there. Then we've got a dense area of woods and a very steep drop off before we get to the residence at 190 Turkey Roost. Nobody would ever think in a million years that this is not on the Hugars property. Next, I'd like to bring your attention to General Statutes Section 8-13A, which I've highlighted here. This concerns non-conforming structures, and you may already know this, forgive me, but what the statute says is that if a building or a structure violates a setback, and that structure has been in place for at least 3 years without any zoning enforcement action by the town, then the structure is deemed to be a legal non-conforming structure. So that's what we have here. This shed has been in its current location for at least 16 years. So those are really the conditions that are driving this variance application. So I reached out to Ms. Gallagher when we were trying to work this lot line revision, and she advised me that we would need to file this application for variances before the lot line revision could take place. Rather than a traditional hardship analysis, the Hugars are proposing to reduce existing nonconformity with respect to this shed, which is an independent basis for granting a variance under Connecticut law. So not only is the shed legally non-conforming as to its current setbacks, but it's also non-conforming in the sense that it's an accessory building, but it's not within the record property boundary of the principal building on the same lot. And the Monroe zoning regulations define an accessory building or structure as, quote, a detached building or structure or a portion thereof, the use of which is subordinate and customarily incidental to the principal use on the same lot. And that's the important language there, on the same lot. The variances we're requesting would allow the Hugars to apply for the lot line revision to correct this nonconformity by causing their accessory shed to be located on the same lot as the principal residence that it serves, which is namely their house. You also have in the record before you tonight a letter in support of this application from Julio and Cindy Ochoa of 190 Turkey Roost Road. The last sentence of this letter, I won't read the whole thing, but it says, we fully support the Hugars variance application, which will allow us to complete our settlement negotiations and to resolve the existing nonconformity. So lastly, I'd just like to highlight what would happen if these variances were denied. So the Hugars would then be in a position where they had no choice but to sue the Ochoas for adverse possession in order to be able to access that well cab and that shed without technically trespassing. And if they prevailed in court, the court would enter an order that would set new boundaries between 81 Georges Lane and 190 Turkey Roost Road. And that order would take precedence over the Monroe zoning regulations. So in other words, the Hugars would likely be able to obtain a larger piece of property than is proposed to be transferred to them as part of this settlement agreement. And that would make 190 Turkey Roost Road a non-conforming lot because it would then be less than 1 acre. So this application, if approved, would, for that reason, also result in an overall reduction in nonconformity for both lots. And we believe that the application should be approved for that reason as well. So to conclude, we are asking for variances of section 3.1.5 to allow a 0-foot side setback and a 4.5-foot rear setback for 81 Georges Lane. And we'll be happy to answer any questions that the board may have. Here, I'll stop sharing this.
Yeah, can you take that? Yeah, thank you. Thank you. I'll open it up to the board. If just raise your hand so I can see if any member of the board has a question. I see Ron. Go ahead, Ron. Oh, you're on mute, Ron. I'm sorry.
Many people wish they had the ability to mute me. Okay, so the sideline setback appears to abut to another party. That property appears to be owned by Wayne and Robin Hoffman. Do we have any indication how the adjacent property owner might feel about the reduced sideline on that shed?
So other than that, they received a copy of the abutters mailing to, indicate that this application was on for tonight. No, I haven't had a specific conversation with them. But I would also just note that, the placement of the shed, it's been there for a very long time and it's already legally non-conforming as a pre-existing non-conforming use based on its amount of time in that location under the statute that I referenced. So really, I mean, the shed won't be moved either way. It's just a question of, can we technically accomplish the lot line revision with a new property boundary? And I believe it's Ms. Gallagher and the town's position that the variance would be required before we do that.
Does that answer you? Go ahead, Ron, if you've got more questions.
It does answer it. Thank you very much. The other question becomes, a survey was not performed at the time of property transfers.
I can answer that as to what happens with the town. No, we don't require, unless, either party purchasing or selling it, voluntarily does that. The town does not require for a property survey to be done when a property is bought or a transfer of ownership.
Thank you, Kathleen. I was not clear on that. Thank you.
Anything else, Ron?
No other questions?
Okay. Christina, do you have a question?
My only question is if ever just easements were discussed as far as the shed, if an easement could have been given for the duration of the ownership of the parties instead of the redrawing of the lines. No,
Yeah.
I'm not sure.
Yeah, so that was discussed as one potential way for this to work.
Mhm.
Just it wasn't the option that we ended up landing on. There is in connection with this lot line revision, and you can see on the lot line revision plan itself, there is an easement component to the settlement regarding access, maintenance of this particular garden that's also right on the property line. Uh,
Mhm.
but I think it was both parties' preference, from my recollection, to do it this way and just have it be a little bit more final,
Okay, thanks.
of course.
So I have a question on the shed. You said it's not movable. Is it a permanent structure, or is it a shed that could be moved?
Sorry, so I didn't mean to say that it could not physically be moved, just that there is no present intention to move the shed, or there's no, the shed is not proposed to be relocated as a part of this application.
I see, Margaret, you have your hand up. You have a question?
Thank you. Just a couple of things. If the structure currently is a shed, will there be any restrictions on any other possible structures that might be built? Should that shed be removed? Could another building entirely be set on that land? And how would the town control for that?
Yeah, it's a good question. And one of the ways that the town or that this board could remedy that issue, if you thought that that was something, that you were concerned about, is that you could condition the granting of the variance application on the location of the shed as depicted in the lot line revision plan. And I actually have an example, if I could just briefly share my screen again. Forgive me, so this is from a decision that my office worked on from a ZBA application in Westport. It's just an example of this type of condition. So this application was granted upon the condition that all construction and improvements shall be in strict accordance with the plans and other documents submitted in any statements or representations made by the applicant or agent on the record. And any deviation from such documents or representations shall require further review and approval from the board. So, I understand that a change in the setbacks could potentially have, more far-reaching implications than just this particular shed. And if, the Hugars have not expressed to me any intention to build any other structures on their setbacks using this variance, but to the extent that that's a concern of the board, we don't have any objection to conditioning the approval on the location of the shed as depicted on the lot line revision map.
A follow-up to that would be for me, what happens though when somebody else buys the property? And they won't know that this restriction exists, and they could just knock it down and try to put something else up. How could that be?
I can respond to that. Yeah,
Oh, great.
Jim went for the record. Firstly, any variance that this board grants runs with the land and is recorded on the land record, so any subsequent owner is entitled to that same variance. But in my response to your initial question was, well, I do appreciate the applicant's offer of that condition, and if the board wishes to take that up, we certainly can. But in my opinion, if that shed's removed, or any future addition or structure would have to comply with the setback requirements in order to obtain a permit for construction. And if it doesn't, and if it's within the setback, it would require review from this board for relief. So if a future owner or this owner removes the shed or wishes to build something else that we're not seeing now, if it doesn't comply with that rear or side yard setback requirement, that would have to be the subject of a subsequent application before this board.
Okay, thank you for that. I just have one last question then. It's a quickie, I think. Will a new, very obvious, again, my concern is that the jagged nature of the land outline and the fact that errors could happen again. Is there going to be a new fence put around so more to clearly demarc the new arrangement? Or how will it be made visible, clear, so that any subsequent owners will know exactly where the lot line is?
Yeah, so the first portion of that question is the reason that the lot line was drawn in that way was because the lot at 190 Turkey Roost Road it's like 1 point. I can look back at the lot line revision plan. It is let's see, 1.026 acres. So, and this is a 1 acre zone, so the lot is required to be at least 1 acre to be zoning compliant. So we had a pretty small, it's a 1,125 square foot area of play to work with to keep both lots zoning compliant. So that's why we had to draw it that way. I think it would have been, you know, if we could have done a straight line, I think we would have, but this is just designed specifically to make sure that both lots remain zoning compliant. And then with respect to how will that be demarcated, the surveyor will be placing, you know, iron pins on the relevant portions of that property to demarcate where the line is.
Okay.
And also the land that's being transferred, our surveyor Tracy Lewis has drafted a legal description of it. So even if there weren't pins there, a surveyor could take that legal description, go out into the field and remark that location based on the description that the surveyor prepared.
Okay, because there can be a lot of pins there in that particular piece of property. I want to commend you on the thoroughness of your presentation, by the way.
Thank you. I appreciate that.
And thank you for hearing me out.
Yeah, of course.
Any other members have any questions at this point? Okay, seeing none, I will move on. Are there any members of the public that have any questions or wish to be heard on this matter? Go as
Can you see our hand?
I cannot see. Oh, there I can now. Go ahead. You're here, so you might as well. You
Hi,
obviously are here for a reason.
Yes, Peter and Janice Holmes. We were just notified of this hearing. We own the bordering property to the Hugars, and we were invited to this hearing. We're just wondering if there are any implications to the property we own at 87 George's Lane.
Where are you relative to the shed?
I believe.
That's their backyard, which is farther behind our backyard, I guess you would say. Our properties are a little uneven.
Okay.
Yeah, I can actually, if I may, I think I can pull up. If I can just share my screen one more time here.
Yeah, sure.
Yeah, so
So are you at 80? I'm sorry, you 87 George's Lane?
Correct.
right,
Okay.
so right here, yeah.
Okay.
So nothing on the ground is going to be changing at all. It's just that the boundary between these properties, the record boundary, changes so that the shed and the well cap will be within the envelope of 81 George's Lane. But you know, nothing. There's not going to be a shovel in the ground. There's not going to be nothing's moving. It's just sort of a rearrangement of the line, so that what's actually on the property will conform to, you know, what everyone's understanding of the property boundary is.
And so no implications as far as our property boundary at all?
Nope. So yeah, let's take another look at the lot line revision here. So the only change is that, so this dotted line, this horizontal dotted line is the existing property boundary, and that's only shared between these two properties.
Mhm.
And then that's just going to be sort of extended right along these dots to include specifically this well cap and the shed, but there'll be no change to any other property boundaries.
We were just invited out of courtesy to be
No, that's
where.
fine.
Well,
We're happy to have you. I just said another way. The common side yard property line between you and the Hugars is not proposed to be altered.
Right. And
Very good.
as
You're free to ask. You're welcome to ask any other questions you may have, but we're happy to have you join us.
yeah, and the law says, you know, anytime there's an application like this, the applicant has to send a letter to every property
Nice.
in 100 feet. So that's why you.
Well, appreciate it. Thank you.
Thank you.
You all set?
Also,
Okay. Anybody else? Kathleen, is there anybody on the phone that we can't see on our list here? I'll just say going once, going twice for any other members of the public that I might not be able to see on the
I
screen.
don't see anybody else.
Okay. All right. Well, hearing none, we'll close public comment. Mr. Carroll, do you have any closing remarks? Or are you all set?
Nope, that concludes.
All right.
it.
I will say that I did speak to the health department, and the health department is very much in favor of having the well cap being on the correct property line. And as it relates to a future lot line adjustment, I have no objection to them submitting a lot line adjustment if this variance is granted. And I'm very happy with their efforts to make sure that the lot sizes do not become non-conforming, and they can still remain 1 acre lots.
Thank you for that. If there's nothing else, we will close the public hearing on this matter.
Thank you.
And we will go to our deliberative session. We have pending minutes from the last meeting. I was not present at that last meeting, so I will abstain from that vote. But if you folks have had a chance to look at those meetings for December 3rd, I will entertain a motion for the minutes of December.
Motion to approve. This is Ben Maini.
Ben moves to approve. Is there a second?
I'll second. Ron
Okay.
Stelmack.
All those in favor of the motion to approve the minutes, say aye or raise your hand.
Aye.
That is a 4-0 to 1 vote to approve the minutes. Okay, we'll move on to this next file. This application before us for the setback variance. At this point, since it's only the regular members voting, the discussion will be limited to that. Is there anybody wish to make a motion on this matter?
Ben Maini. I'm going to make a motion to approve or to move it forward
Okay.
as presented, given that the shed's been there for 16 years and hasn't really moved. And the redrawing of the lines brings both lots in conformity.
Sarah, were you raising your hand? I'm not Sarah, I'm sorry, Christina, were you raising your hand to make a motion?
I was,
Is that-
well, I'll second now
Okay,
to
thanks.
approve. Yeah.
All right, motion by Ben, seconded by Christina.
Yeah.
Ron, comments?
Sure, I would like to see that amended to constrict this to the existing shed, its footprint and its nature. Essentially addressing the concern that someone expressed about, could this be extended in the future? I know you, Jim, you indicated that down the road regulations would prohibit that. Regulations can change down the road. So I'll try to come up with some words to make this simple.
Oh, I hear what you're saying, Ron. I have no issue with that. I think we could just simply adopt the language that was offered by the applicant as a condition of approval.
That works.
And if Christina, I'm sorry, Kathleen, if you don't have that language, if that wasn't submitted by Mr. Carroll, and we can go back and look at his language that he had proffered, but suggested language for condition of approval. So Ron, you're suggesting that we tack that on as a condition that with that sample language that was offered to us.
Yes, please.
So the
Ben?
language that was offered was this variance application is granted upon the condition that all construction and site improvements shall be in strict accordance with the plans and other documents submitted, and any statements or representation made by the applicant or agent on the record. Any deviation from such documents or representations shall require further review and approval from the board.
Ben, Christina, are you okay with amending your motion to include that condition?
Yes.
Yes.
Okay. I have no objection to that condition. Personally, I commend this applicant and their neighbor for working this out amenably. Unfortunately, it does have to come before us to cure this one technical matter, but I think this is a much better result than the best result that could come of this. So I commend all parties for their cooperation in this. Sarah, do you have anything to add or say before we call for the vote? No. Okay. All right, unless somebody else has anything further, I will call for a vote on the motion to approve with the condition as read. All those in favor say aye.
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 Raise your hand. I see Sarah raising her hand. That is a
Sure.
unanimous 5-0 approval. Thank you, everybody. And unless, Kathleen, we have any further business we need to discuss, we will adjourn. So thank you, everybody, for your time and attention. Have a great week.